Everybody, in this tutorial we're going to be looking at the last of our general defences, and these are duress and necessity. So first of all I'm going to take you through duress, and we can break duress down into two types, duress by threats and duress by circumstances. So I'll take you through the requirements for this defence, and then I will take you through necessity. The two overlap because essentially what duress and necessity are about is a defendant saying that they were forced to commit the crime. And duress in particular, duress by threats being the most common form of duress to be raised, is a defence where a defendant is saying that they were forced to commit a crime as a result of threats being made against them or another identifiable person to them, like a family member or a close friend. And there is a definition of duress that comes from the case of Whelan, which you can see here on the screen. Threats of immediate death or serious personal violence, so great as to overbear the ordinary powers of human resistance, should be accepted as a justification for acts which would otherwise be criminal. So if you've committed a crime under duress because you've been threatened with death or serious personal violence, and note that that has to be immediate death or serious personal violence, then that could be accepted as a justification. So this, if successful, is a complete defence. So it means that the defendant would walk away from any liability. So by nature of that, it's very difficult to prove, and there are a lot of strict requirements that we will need to go through. So essentially, the defence negates the voluntary act. So it negates the actus reus in a way, because what we're saying is, but for the threat, the crime would not have been committed. So that defendant would not have intended to commit the crime, and certainly did not complete a voluntary act in the true sense of what it says. So complete defence for most crimes, and this is why we call it a general defence, because historically it's been available to all crimes, but there are some limitations now. And the two main limitations you will hopefully be familiar with, because we've looked at these cases before, are that duress cannot be available to crimes of murder. That comes from the case of Howe. It also can't be available to crimes of attempted murder, and that comes from the later case of Gotts. Now, it's interesting that this is a limitation, because when you think about duress and when you watch films that include this defence being in action, you often get like a person who has to kill the baddies to save their family or whatever. This is, a similar kind of duress type instance. They often are not facing criminal charges because they're seen to have done a good deed. But actually, the reality since the late 80s is that we can't raise this defence to these really serious crimes, even though you could argue that these types of crimes may be committed quite easily under duress. So we'll have a look at the facts of these just as a refresher. So you've got the case of Gotts and you've got the case of Howe. So in Howe, this case actually involved more than one defendant. Two defendants that appealed were Howe and Bannister. So Howe and his co-defendant, and Bannister is Bannister, they joined a criminal gang, but on the facts they didn't appear to understand the severity and the nature of what the gang carried out. What they did was they were party, or they were at least present at the torturing and killing of 2 people. And there was a third person that managed to escape. So there was another charge as well. Now, they were both convicted of murder, even though they raised duress, and they appealed to ask the Court of Appeal to review this case as well. They even appealed to the House of Lords, as it was then. And actually what was ruled was that duress should never be available to the crime of murder. So this case actually overruled a previous case called Lynch, if you see at the bottom, where duress was available. It was available for a getaway driver who basically was acting for the IRA, Northern Ireland terrorist group. So they were involved in their crimes under threats. So the law has changed. You never know, it may change back, but it's certainly been the same since Howe, and seems to be a real limitation of the use of this defence. Gotts, similarly, this was a crime of attempted murder. So this was a young defendant, late teens, who tried to kill his own mother by stabbing her. And when he was arrested, he claimed that his father had threatened him, so he had acted under duress. He too was unsuccessful. And actually, what the House of Lords on Appeal did was that they used the obiter dicta. Hopefully you remember that term, Latin for other things said. They used the obiter from the ruling of Howe, which said if this was a crime of attempted murder, duress would also not be a defence. So they used that part of the judgment to rule that duress shouldn't be a defence in this case to attempted murder. So if you remember from your lawmaking, your precedent lessons, the obiter from Howe being used to make the decision in Gotts therefore makes this principle the ratio decidendi, the reason for the decision in Gotts. So Gotts was also found guilty. Okay, so the 2 main limiters to start with. So essentially, I talked earlier about a defendant not fully being voluntary because they're being forced to commit the crime. But I guess legally you could argue they make the decision to commit the crime, both physically and mentally. So the elements could still be made out. But essentially, the way the defence operates is that their full willingness and voluntariness is overborne because they have received personal threats, or their family members have received personal threats. So the threats have to have been made against either the defendant, a member of their family, or by an identifiable person, somebody who they are responsible for. Like in the case of Hurley, the defendant was allowed the defence when threats were made against his girlfriend. So somebody who there would be that close relationship and that element of responsibility. And of course, that comes from the Whelan definition, the defence must have been based on the defendant having received threats of death or serious harm. So if the threats are of anything less, then this could go some way towards mitigating their culpability in sentence, but it's not going to be a defence. So there's a case to evidence this first requirement, and that comes from Valderrama Vega. So love the name. Valderrama Vega was caught smuggling cocaine from Colombia. He claimed he was under duress from drug barons who threatened to kill him and his family, but also to expose his secret homosexuality and the fact that he was under financial pressure. So if you think about all of those threats there, which one or ones are the most serious? Which ones would satisfy this requirement. So the courts decided that the threats to kill him and his family were sufficient, but the other threats were merely going to be used in mitigation. Okay, if he was convicted, but he was luckily successful. So that's the first requirement. So when you're summarising this law, you should start with the definition of the defence, the limitations in relation to murder and attempted murder, and then you can list the requirements. So requirement 1, we've just gone through. And we will go through the other requirements in a second, but I just want to take you through the test for this defence. The test comes from the case of Graham. So how do the courts determine, not just with the requirements, but also whether a defendant has genuinely been acting under duress? So the facts of Graham are that he lived with his wife and homosexual lover. He'd been taking drugs for anxiety, which had made him more susceptible to bullying. So they'd both been drinking, and his lover threatened him into killing his wife. So if you note, this is prior to Howe, by the way, as well. So the trial judge directed the jury as to duress, but Graham was convicted. And on a court of appeal, this conviction was also upheld. They didn't regard the threats as sufficient enough to constitute the defence. And what they did was they set a test. So the test comes from obviously the case of Graham, and what the jury or magistrates, if this was a lower level, have to consider are 2 key questions. So firstly, it's a subjective element. Was the defendant impelled to act in the belief that they would be killed or physically injured if they didn't comply with the threats? So on the evidence, did this defendant feel that they had to act, essentially? And that did they genuinely have that belief that they would be killed or physically injured if they didn't act as directed? That's subjective. And if yes to that question, then the jury can move on to the second part, which is, would a sober person of reasonable firmness, sharing the same characteristics of the defendant, have acted in the same way? So this, hopefully you've identified, is the objective part. And interestingly, if you look at the wording, reasonable firmness, sharing the same characteristics. Now, characteristics, as we've seen with other tests, would most likely be age, sex, and similar characteristics like that. But a sober person of reasonable firmness, interestingly, Graham had been taking drugs for anxiety. He was susceptible to bullying. Would we call him a person of reasonable firmness? This indicates that this person has to have no mental health issues or susceptibility to any weakening of the character, if you like. So it's a very strange way of looking at it, because if you're going to compare Graham to anybody who is a person of reasonable firmness, he will always fail by nature of that test. So it's a real criticism, actually, of this test. Really interesting evaluation point. I'll just go into it in a bit more detail over the page. So there was a case a bit later, the case of Bowen in 1996, where the defendant had low IQ, so raised duress, but failed on that second part objective test. Because, of course, if you're of low IQ, you're not going to be of average fortitude, strength and firmness of mind, as I say above. So the Court of Appeal did not allow Bowen's low IQ to be taken into consideration. Okay, they don't recognise any additional conditions that the defendant might have. So we are purely basing the defendant on characteristics, like age and sex that are not susceptible to change. So really interesting point. We had some later cases, 2 cases that had joined up to appeal against their convictions and the failing of Duress, Hegarty and Horn. So you can have a look at these cases online, all really interesting. The Court of Appeal here too rejected psychiatric evidence of vulnerability. So if you are vulnerable to threats and you're targeted and you commit a crime as a result of that, duress will still not be available to you because you'll fail the second part of the Graham test. When the jury or magistrates consider your actions against that reasonable person, you're going to fail. That's just really, really interesting criticism. Okay, so that's the test. So let's go back to the requirements. So we've got requirement 2, which again we could take from the definition, this concept of immediacy. So immediate death or serious violence has to be the threat. So the threat must be unavoidable and imminent. And we know from other cases, imminent basically means immediate, as immediate factually as possible. So if a defendant has time to inform the police, for example, or to avoid the crime, the defence will not be available. And this happened with Gill in 1963. He stole his employer's lorry after being threatened, but on the facts, he had time to go to the police before doing so. So duress was simply not accepted because the threat needs to be imminent. Okay, the third requirement, the threat must have been directed at the commission of a particular offence. So I will explain this to you, probably best so with the leading case, Cole. So the defendant was charged with committing robberies at a number of building societies. He raised duress because he said he owed money to people who had threatened him, obviously with at least serious harm, if he didn't repay. Now, he was convicted and appealed, and his appeal was dismissed because the threat was that he had to repay the debt. The threat was not to commit a crime. So if you think about it, he could have potentially taken out a loan, borrowed money. You have to have been forced to commit a crime. And I suppose you could argue this was an indirect forcing to commit a crime, but ultimately this is probably a policy decision where the court's seeking to make this criteria strict. And could you imagine if we allowed more defendants to raise duress because they've decided to commit a crime to save themselves from a debt or from another hardship? It really does open the floodgates for those potential offences to be committed and be avoided. Okay, requirement 4, really important one, and could rule out again a lot of defendants. The latest case is called Hassan. Essentially, what this requirement is that if you induce the duress, you will not be able to rely on it. So this really comes from situations where people join gangs. If you think about Howe and Bannister, they joined a gang, although they weren't aware of the nature of the activities or the seriousness of what the gang was involved in. I think we would all agree, by nature of joining a gang, you should expect or at least foresee the possibility of unlawful activity. And that's certainly the line that the courts take. So if you induce your duress situation, and this could include association with gangs, and you then end up being forced to commit a crime, you will not be able to rely on the defence. So a man must not voluntarily put himself in a position where he is likely to be subjected to compulsion. So he is likely to be subjected to forced behaviour. And that comes from Sharp. There is a later case of Shepherd in that same year, 1987, where the court said it would be up to the jury to decide whether this is an association and a foreseeability of the type of conduct you would have to engage in. And you see the facts of Hassan in the later case, 2005. Hassan was the driver for a prostitute whose boyfriend threatened him with violence if he didn't commit a burglary. He was unable to rely on the defence, and the House of Lords, as it was then, actually termed or coined this type of situation as self-induced, regardless of whether he had foreseen that he might be forced to commit a crime. Through the nature of the activities he was engaging in, it was likely. But it's up to the jury to decide that. It's not necessarily a question of subjectiveness. Really interesting. So that is duress. So let's just have a look at some scenarios. I'd like you to just have a quick read of these, please, and just identify whether you think these defendants would be able to rely on duress. And if not, what the issue might be. Might they fail on a requirement or the test? Okay, so hopefully you've had a look at these now. So A, hopefully you've identified most likely she'd be able to rely. There may be a question of whether she's induced her situation because she's associating with her boyfriend who has several convictions for violence. So Hassan may play a part, the fourth requirement there. For B, hopefully you've identified that Jazz would be unsuccessful because the threat was not imminent. So Gil would be the relevant case there. Hopefully C, you've identified that Louis is, again, would be unsuccessful because the threats were not serious enough. Threatening to tell an affair is not serious enough. And hopefully you've identified the same for D, that Paul would not be successful because, again, the threats are not of death or serious injury. For E, hopefully you've identified Bert would likely be successful. And for F, hopefully you've identified that Kath is likely to be unsuccessful because, again, the threat is not imminent. Okay, so let's move on to duress of circumstances. Really small because it's very limited, usually used in driving offences. Again, requires fear of immediate or imminent death or serious injury. And it essentially refers to instances where defendants feel forced to commit a driving offence or an offence because of the circumstances they have found themselves in, rather than being threatened. So this is more of an indirect situation of duress rather than a direct. So let's have a look at some of the cases. So we've got the test to establish duress by circumstance from the case of Martin. So Martin drove his stepson to work even though he was disqualified because his wife threatened to kill herself if he didn't. He was originally convicted, but then the conviction was quashed and duress was allowed. And a similar two-stage test to Graham was formed. So you've got your first layer of subjectiveness. Did the defendant believe that death or serious injury would result? Were they compelled or impelled to act? Secondly, if so, would a sober person of reasonable firmness have acted in the same way? So very, very, very similar, almost identical test there. And a similar case that you could use in the same year, Conway, Defendant sped off from men chasing him, not knowing that they were plainclothes police officers. Originally convicted of reckless driving, and the conviction was quashed by the Court of Appeal. Duress was not allowed to be considered at trial, but it should have been. Okay. So we're now going to move on to our final defence for criminal law, which is necessity. Again, this is very small. It is very similar to duress of circumstances. It refers to situations where defendants feel that it was necessary to commit a crime through the situation they find themselves in. The problem with this defence is that it's extremely rare, rarely successful. It wasn't actually considered to exist until the case of Rie conjoined twins. In other words, not that it hadn't been raised, but it hadn't really been successful. And hopefully you remember Rie conjoined twins and the facts. So remember, they were two twins born early 2000s, and they were conjoined, Mary and Jodie. And Jodie had all organs to live a functioning life, and Mary didn't, and was effectively sucking the life out of Jodie. So the doctors applied to the courts for a declaration that they could separate the twins with an operation, and therefore allow Jodie to live. But unfortunately, as a result, Mary would not survive. The parents opposed the application. Of course, no parent wants to have to ever make that decision, and I believe that there were religious reasons as well. So this case went to the Court of Appeal. This was a civil division case. It was a civil application. This wasn't a criminal matter. But interestingly, the civil court or the civil division used criminal principles to make their decision. Their decision was to allow the operation to go ahead, and as far as I'm aware, it did. And they cited two criminal defences. If you look on the right-hand side of this screen, Lord Justice Ward said, "The court is not a court of morals, and I consider the operation would be lawful self-defence, i.e. the doctors would be coming to the aid of Jodie." So in actually making the judgment, they cited that the doctors would be acting in defence of Jodie, and that therefore made the operation lawful. And on the left, they cited the operation as being necessary. And they actually seem, in the judgment, Lord Justice Brooke certainly seems to be forming a test. So if you look here, the requirements for necessity, the act was necessary to avoid inevitable and irreparable evil. Secondly, no more was planned to be done than was reasonably necessary for the purpose to be achieved. And thirdly, the evil to be inflicted was not disproportionate to the evil to be avoided. So essentially, we had recognition of necessity and a test being formed. But do please remember, the facts and the circumstances of Rie conjoined twins are so unique that the Court of Appeal did say this should not set a precedent for future cases. Every case involving the decision to end a life should not really set a precedent, because every case is so unique. The importance of this is the relationship between civil and criminal division, as I've pointed out, but also the formation, if you like, of this defence of necessity and what looks like to have been a test. So let's have a look at three key cases here where necessity has been considered. So we've got Dudley and Stevens, which is one that hopefully you're familiar with. Very, very old. 3 men were shipwrecked, went without food or water for 20 days. They decided, or 2 of the men decided to kill and eat the cabin boy. They were rescued 4 days later, charged with the cabin boy's murder. And they raised necessity. They had to commit murder in order to preserve their own lives. They were unsuccessful. So this was not a successful case. So it looks like necessity is ruled out for murder. Then you've got a civil case opposite Southwark London Borough Council against Williams, and this was a Lord Denning case. So this was where a family appealed against their eviction from an empty council home on the basis that they would be made homeless. They cited necessity, squatting in the empty council house for necessity, which you can totally understand why. So Denning did not allow them to remain in the council home, and by way of obiter, so in the judgment, he remarked that the same could be applied to those who are hungry and they claim they stole in order to feed themselves. He said this opens the floodgates for offending based on personal necessity. In other words, he'd never want to allow somebody a full defence to theft if they stole because they were hungry. Seems very harsh, doesn't it? It would certainly be mitigation, but I guess the role of an appeal judge is to make sure that any decision they make does not open the floodgates for further claims and mass acquittals or convictions, on the other hand. Okay, and the final case is of Shayler. So Shayler was a former MI5 officer who leaked confidential information to the press. And when he was charged under the Official Secrets Act with this act, he claimed necessity. He felt it was necessary to alert the public of wrongdoing. And the Court of Appeal, in this case, ruled that the defence was not available to him. They said that there were no threats of imminent death or serious injury. So this is the most recent case we have, and it appears that necessity will certainly not be available for those who appear to be vigilantes, if you like, and are not under threat, or certainly with Shayler, you can see that it wouldn't have been a necessary act in the true sense of it. And that is the law. That is totally the law covered. Just have a look at the next slide. What we have here, taking you back to Duress, is an essay plan based on the usual type of question that we look at around the defence being outdated, not fit for purpose, in need of reform, and you need to evaluate the defence in terms of breaking down the test, the limitations, the requirements, and then of course other issues as well. So I would like you please to have a go at completing this plan. I've given you the evaluation points on the left hand side and some more cases to look up, and then I would like you to try and develop them and form a plan. Duress and necessity have been application questions before. Certainly duress, you're more likely to find in a scenario than necessity. Necessity has not been assessed by OCR for many years. But where you would more commonly find these is in an essay question. And they could be both lumped together because necessity is so small. So it might be a question requiring you to evaluate both defences together. Now, of course, duress by threats is the biggest one, so it's certainly the one you should focus on. But do please make sure that you have notes with the cases for duress by circumstance and necessity as well, because they certainly overlap. And I'd never put it past OCR to give you an essay question on those two. So I would like you to have a go at those. And there will be opportunity in the autumn to have a go at application. Okay, we have made it. So you've finished duress and necessity, and you've also finished criminal law. So very well done. We've really worked hard over these last few months to cover such a big area of law, and I hope you've really enjoyed it. I absolutely love criminal law. I think it's a minefield. And I think there's just so much to talk about in terms of the cases and the evaluation points. In your booklets, there is a duress article, so please do make sure you read that and highlight it as well. And if you would like any more application questions, please do email me and let me know. But I hope that you found this really useful, and I look forward to the next one. Thank you.